morning to all our MSMEs. First of all, I would like to thank the Department of Trade and Industry, particularly the Bureau of Domestic Trade Promotion, for inviting the Intellectual Property Office of the Philippines, or IPOPHIL, today. So this morning, I'd like to share with you how you can protect your brand so that you'll be able to gain competitive edge in the market. So this will be more of an introduction to one of the most popular intellectual property rights, that is trademark. First off, I'd like to introduce to you what intellectual property is. Intellectual property is a creation of the human mind. Now, if you have your creations, how do you protect them? So we have here keywords that would help you understand the different intellectual property rights. Okay, here are the different intellectual property rights. And to easily recall them, we have the following keywords. When we say invention, we mean patent. Okay, now the improvement or innovation of an existing invention that may be protected by utility model. The aesthetics of an item can be covered by industrial design. Industrial design is more of the physical appearance of a product. And for your creative works, you have copyright. And lastly, of course, your brand, your name, the symbol or logo, that would refer to trademark. And this morning, we will focus more on trademark. Here's just a quick guide for you to be more familiar with the different intellectual property rights. Do you know that an item or a product could consist several intellectual property rights, just like this ice cream here? Of course, the process of producing the ice cream, that would cover patent. Now, if you have a cone, you were able to come up with the design of the cone for your ice cream, then that design or the physical appearance can be protected by industrial design. And if you have advertising materials so that consumers could easily recall your product, then that would be under copyright. And of course, the name or the symbol that you put in your product so that consumers can easily identify that this product belongs to your company, then that would be trademark. So remember that one product can consist of several intellectual property rights. Intellectual property rights are exclusive rights. And what do we mean by that? That means that the intellectual property owner should be the one to safeguard his or her intellectual property rights, his rights. Okay? And also, only the IP owner is able to enforce his or her rights. Okay? We also have to remember that an intellectual property can be an asset. How? Because if you are an IP owner, then you get the exclusive right to sell, assign, transfer, license, franchise, commercialize. Therefore, you have the exclusive right to earn and profit from your intellectual property. Also, because of your intellectual property, you can increase the market value of your business. And it can also be a form of inheritance. Pwede itong ma-transfer sa mga anak mo or sa apo mo later on, because there are intellectual property rights that have longer term of protection, such as patent has 20 years from the filing date. Industrial design can be renewed for 3 consecutive 5 years. So that would make up to 15 years. And then trademark, merong forever sa trademark, but you have to use and at the same time maintain your trademark. Yung trademark actually has a term of protection of 10 years, but can be renewed as long as you're using it and as long as you're maintaining it. Okay? So remember that intellectual property can be an asset or is an asset. how do I patent my trademark? Oftentimes we get this question from our clients or from our applicants. They would come to the office and ask our information officer, paano po ba ipapatent ang aking logo or ipapatent ang aking pangalan? Do you think the question is correct? Of course, it is not correct for the simple distinction that when we say patent, we refer to the product, the process, or the invention itself, as I mentioned a while ago. Whereas the name or the symbol or logo that you put in your product, so that once you put it out in the market, consumers could easily recall that this product comes to your or is from your company, then that is trademark. Therefore, this question, how do I patent my trademark, is not correct. Okay, so never be confused anymore. Now we will focus on trademark. The keyword for trademark is branding. And branding, of course, is a marketing strategy. Whereas trademark is the legal protection that you have with your brand or with your branding. So trademark is an intellectual property right. It's the legal protection that you put in your brand. Okay, I'd like you now to identify the following images. Let's see if it would be easier for you to identify them. Okay. Was it easy for you to identify them? They may not be even complete, just like this one or this one. But were you able to identify them? Why? Because that is exactly what a trademark does. So in the next few slides, we will know more about trademark. The Intellectual Property Code of the Philippines defines trademark as any visible sign. Remember, it's a visible sign distinguishing the goods or services of an enterprise. Okay, it may be a name, a symbol, a logo, a brand name, tagline, or even mascot. Okay. And as mentioned, trademark owner has an exclusive right to use, sell, license, and of course, profit from his trademark. And once you have your trademark registration, it gets a term of protection for 10 years and can be renewed every 10 years as long as you're using it and maintaining it. Kaya nga, sinasabi natin may forever sa trademark. But of course, just like in a relationship, the trademark is also or should also be maintained. At the bottom of your screen are more examples of trademark. So just for you to be more aware, so LG is a trademark that identifies goods for appliances, and Smart is a trademark that relates to services or telecommunication services. So pwedeng goods or services. Okay, you may use your trademark for your goods and your services. Now, what are the kinds of marks that you can register? We have types of marks according to composition. Ito lang, ha? This is just an enumeration. So a trademark can just be simply a word, such as Nike. It can also be just a symbol, such as the swoosh mark. Pwede rin siyang phrase, just like just do it, or tagline. Okay? And a combination of a word or the symbol swoosh. Okay? More examples. Pwedeng, example, National Bookstore, a word mark, or a symbol, or a device, just like the bench device by bench. Or it could be a tagline, a slogan, such as Kapuso ng Pamilyang Pilipino, anumang kulay ng buhay. Or a combination of all these three. Ito. So you have the word Meralco, the device or the symbol, and then yung kanyang tagline or kanyang slogan na may liwanag ang buhay. Okay? It could also be a three-dimensional figure or a stamped container. Okay? So aside from the types of mark according to composition, we also have types of mark according to strength. This is very important, you know, because of course the registrability of your trademark would depend on the strength of the trademark that you file. Okay? It has been said, or it is said, of course, that a strong trademark is easily registrable and can easily obtain protection. So ano daw yung strong mark na sinasabi that can easily obtain protection? We have what we call fanciful. Okay? What is a fanciful mark? It's just a made-up words. Parang coined words lang siya. It has no meaning. It has no dictionary meaning, such as Kodak or Google. Okay? So ito daw ang strongest of all mark, fanciful. Next, you have an arbitrary mark. When you say arbitrary, we mean that this word can be found in a dictionary. Meron siya talagang meaning. Yung word has a meaning, but that meaning is unrelated to the goods or services that is being used for. For example, we have the word mark apple. You know very well what an apple is. Apple is a fruit. But in this case, apple is a mark for electronics. So apple is an example of an arbitrary. An arbitrary mark has a dictionary meaning, but whose meaning has nothing to do with the goods or services that the mark is applied for or that is being used for. Next one, you have a suggestive mark. In a suggestive mark, there is this hint, okay? But it requires consumers to connect product with the mark. Although it is hinting on something, it doesn't directly say that it is that thing, okay? For example, copper tone. Do you know that copper tone is a nickname used for a person that for a person who does not easily get dark? It would take him enough hours under the sun and still he doesn't get dark or tan. Okay. So copper tone is an example of a suggestive mark. Next one, you have descriptive mark. A descriptive mark merely describes the goods or services. And you have our example there, cold and creamy. If your mark is cold and creamy, what could be your product? It simply describes it. Tama, ice cream. Cold and creamy here for the product ice cream. It simply describes what an ice cream is. It's cold and creamy. And lastly, you have a generic mark. Generic mark, names of products they seek to identify. Okay? They're simply names of the product. And yun na yung kanyang trademark. For example, ice cream. For the product itself, ice cream. Now, where do we draw the line? Fanciful being the strongest type of mark. Okay? Followed by arbitrary, suggestive. The last two here cannot be registered. Okay, so we have a red line here to mean that these two cannot be registered. Okay, or we also have a red line here to mean that these two can be part of your trademark, but they're not solely your trademark. You may use them as part of your trademark. And in the trademark application form, you have a portion there wherein you need to disclaim descriptive and generic marks. You're disclaiming them because you understood that although you use them in your trademark, you use them as part of your trademark, you do not get a sole exclusive right over the use of them. Meaning, anybody who sells coffee can make use of the word coffee in his or her trademark. Okay? We will get to know more about this later on. A trademark also serves several functions. Okay? First, it's a source identifier. When you see these three stripes or this swoosh mark, you know where to find them. You know where to buy them. Okay? You know that these three stripes belong to company A and this swoosh mark belongs to company B. Okay? A trademark is also a differentiator. When you go to the supermarket and you go to this alley, you know exactly what to get because one of the functions of a trademark is that it is a differentiator. Next, it is also a quality indicator. Along with your mark, along with your distinctive mark, there should also be the good quality that you should produce in your product. And when you have this good quality in your product or in your service, then consumers would keep on patronizing your product or would keep on buying them. Okay? And of course, a trademark also functions as an advertising device. A while ago, you were able to easily identify the images, no matter how incomplete they were. You were able to recall them or identify them because most of these companies have used their trademark as their advertising device. Okay? Now, you may want to ask Phil, ano naman ngayon? Why do I need to register your trademark, to register my trademark? Okay? Besides the fact that I already mentioned that intellectual property is an asset, you also get these 3 Gs once you have registered your trademark. What are these 3 Gs? First, there's this exclusivity, grants exclusivity, wherein only the trademark owner has an exclusive right to sell, license, franchise, in other words, profit from his or her trademark. Next, gains recognition and reputation. How? Along with the distinctive mark that you have is the quality that you should, good quality that you should also produce in your product or in your service. And in that way, you gain recognition and reputation because consumers would keep on patronizing your product because of the good service or the good experience that they get, good quality and good experience that they get from your product or your service. And of course, that would generate goodwill. How? They would keep on sharing with their family members, their friends, their colleagues, the good experience or the good quality that they are able to get from these products or from these trademarks. Okay, so 3 Gs are grants exclusivity, gains recognition and reputation, and generates goodwill. There are also marks that cannot be registered. Okay, Section 123 of Republic Act 8293 or the IP Code of the Philippines enumerates the following. Those that are immoral, deceptive, scandalous, and that can disparage cannot be registered as trademark. For example, using the facade of Malacanang for alcoholic beverages. So that cannot be registered. Flags, coats of arms, and other emblems cannot also be registered. Even names, portraits, or signatures identifying a particular individual, like the portrait of Piolo Pascual or the signature of Manny Pacquiao, cannot be registered if you are not them or if you do not have their consent. Even names, portraits, or signatures of a deceased president of the Philippines, such as the signature of President Marcos, cannot be registered as trademark unless there is this consent coming from his spouse. Also, those that can mislead cannot be registered, such as using the mark apple for your product oranges. Okay, and generic, as mentioned a while ago, using the mark Makina for engines cannot be registered. Descriptive as well. For example, using the word matamis for ripe mangoes cannot be registered because it simply describes what ripe mangoes are. Unless the term already acquired distinctiveness or secondary meaning that consumers are already able to identify this word or this mark as a brand name rather than as a mere description of the product, okay, such as Sharp for appliance. Those that are customary to trade cannot also be registered. If you see this pole of blue, white, red, you know very well that there is a barber shop nearby. Therefore, this has already been customary to trade and can no longer be registered. Those that are identical or confusingly similar with an internationally well-known mark cannot be registered, such as using Rolex for a music lounge. And of course, those that are contrary to public order and morality cannot be registered as trademark. Okay. So this one, we love to share with our audience. It's a classic success story in the Philippines. You know very well that Jollibee Foods Corporation bought Mang Inasal. But do you really know exactly how much? Yung initial payment is 3 billion pesos from Injap Investments Inc. Ano daw yung composition ng 3 billion pesos? The 2 billion itself is for IP-related assets. Yes, Mang Inasal is a registered trademark at IPOFIL. And you know very well how Mang Inasal started. It started very small in a kiosk in one of the parking lots of a mall in Iloilo City. But look how it has grown big. Okay. So we as entrepreneurs or as MSMEs, we should not be afraid to take the first step. Okay. You may never know. You can also be Mang Inasal later on or in the future. This is also very important that we would like to share with our audience. The trademark is not the same as business name. Therefore, it cannot be confused. It should not be confused. Okay. A trademark should not be confused with a business name. Okay. You know very well that a business name is registered with DTI or with SEC, whereas trademark is registered with IPOFIL. And the function of a trademark is that it is used as an identifier of a product or service. And of course, the owner gets exclusive right over the use of the mark. Whereas a business name is used in business transactions. Okay? You have to have your business name for you to operate legally, to do your business legally. Therefore, the registration of a business name is required for the owner to have a legal entity. Business name and mayor's permit are needed for the business to operate legally. Whereas trademark registration is voluntary. Although trademark registration is voluntary, we highly recommend each entrepreneur or each business person to file his or her trademark so that later on, hindi siya magsisi na magaya siya ng iba or na manakaw yung kanyang trademark. Okay? So how do you file your trademark now? You already know the registrability of a trademark. How do you file your trademark? We have two routes of protection. The national, which is applied directly with IPOFIL. Of course, our trademark protection is territorial. Therefore, if you do business in the Philippines, it is highly recommended that you file your trademark here in the Philippines. We also have international filing. For example, your business is already successful here in the Philippines and you would want to diversify or you would want to do business abroad, then you can file internationally. We already have this Madrid Protocol. The Philippines is already party to this Madrid Protocol, wherein you will only need to file your trademark, your Madrid Protocol application form here in the Philippines or at IPOFIL, and you can designate the countries you would wish to have business or to do business in that country or in those countries. So are you doing business abroad? If yes, then you have these two options of protecting your trademark abroad. Either you file your trademark application with the IP office of each country in which you want to seek protection of, but this one, of course, is costly because you will need to go to each IP office of every country that you would want to have or to do your business with. Okay. Whereas the WIPO Madrid system or the WIPO Madrid protocol is the most cost effective because, as I mentioned a while ago, you only need to file your application here at the IPOFIL, and from that application form, you could already designate the countries you would want to have protection of. Okay? So ito yon. It's a one-stop solution for registering and managing marks worldwide. You only have to file one application, one language, and pay one set of fees to protect your mark in up to 120 countries. Pero syempre, you would only designate the countries where you would want to do business. Okay? Since most of you have your businesses here in the Philippines and you want to protect your trademark, then how do you protect your trademark in the Philippines? So you have to obtain your registration with IPOFIL, file your trademark application, pay the required fees, and maintain your trademark registration. So before you fill out your trademark application, by the way, since the pandemic began, we have encouraged our applicants to file online. So ngayon, wala nang pumupunta sa office to physically file their trademark applications. Everything is done online. But I'd like to first recommend that before you click on the ETM file, to conduct a trademark search first. Why is it good or why is it necessary to conduct your trademark search? So that you will not lose your money later on, okay? So that at the onset, you already know whether somebody else has already registered the same trademark as you have, or somebody else has already or is already using the same trademark, okay? So that later on, you would know whether you need to change your trademark or proceed with your application. Okay? Kasi once you have filed your trademark and you did not conduct a trademark search and later on the examiner will tell you na may nauna na sa inyo, then sayang ang inyong filing fee. Sayang ang inyong pagod at oras na ginugol sa pag-apply ng trademark. That is why it's important for you to conduct a trademark search first. How? You go to our website, ipofil.gov.ph. So, ito yung homepage namin. Click on e-service. Pag click mo yan, pupunta kayo sa WIPO or WIPO Global Brand Database. So, here, text, just key in or type the name or the mark that you would want to apply for and then key in or click on search. Pag click nyo yung search, all of those related marks will come out. So, from here, you would already know whether you still need to change or proceed with your application. Okay, so as mentioned, we are now into online filing of trademark application, but this is just for you to be familiar. Anyway, it's the same details as you have in the online filing, just for you to be familiar with our application form. Okay. Ito is also important to note that under goods and services, you have to be very particular kasi ang filing fee natin would be per class. Okay? We follow the NIST classification. Key in bit.ly/NIST classification and you will find the classes or the enumeration of this classification of goods. Classes 1 to 45, you have classes 1 to 45, wherein classes 1 to 34 are for goods and classes 35 to 45 are for services. This is how specific it should be. For example, your company sells beverages, that would fall under class 32. You don't simply put class 32, but you have to specify fruit juice ba yan, coffee, etc. Okay. And then, of course, affix your signature. So now, how do you file online? Here's my colleague, Miss Dania Regondon, to walk you through the online filing of your trademark application.
Napakadaling mag-file ng trademark online gamit ang ETM file. Kailangan mo lang magbukas ng browser at pumunta sa ipofil.gov.ph. Kailangan mo lang din hanapin ang Services menu tab at piliin ang e-services bago i-click ang ETM file. Pwede mo rin i-click ang e-services quick link na nasa upper right side ng homepage. Scroll down ka ng konti, hanapin ang filing section at i-click ang file under trademark. Pagkatapos nito, you will be redirected to a new tab at ito na po ang ating ETM file. Set na ang English as the default language. Kailangan mo lang piliin kung anong klase ng marka ang gusto mong i-file. Kung gusto mong mag-file ng brand name, ito yung mga mark na represented ng words, letters, at numbers. Piliin mo lang ang word mark. The next portion, kailangan mo lang i-type ang brand name na gusto mong iparehistro. Ang example natin ngayon ay Lighthouse Coffee. Kung may salitang generic or descriptives ay na-apply mo, dapat mong ilagay ito sa disclaimer box. Ibig sabihin, alam mong hindi lang ikaw ang pwedeng gumamit ng mga salitang ito. Halimbawa, sa mark na Lighthouse Coffee, dapat mong ilagay ang salitang coffee sa disclaimer. At kung gumagamit ka ng foreign words or characters, dapat mo rin i-fill out ang translation box at ilagay ang English equivalent ng mga foreign words or characters. Kung ikaw naman ay nag-apply ng mark ng union o kooperatiba, i-click ang collective mark. Or you may just leave this blank if it's not applicable to your mark. Kung ikaw naman ay nag-apply ng mark na kombinasyon ng images at words, dapat mong piliin ang figurative with words mark. Siguraduhin na ang 1 MB JPEG file na isasubmit ay sumusunod sa nakasaada dimensions. Ulitin lang ang steps sa paglagay ng word mark. Isulat din ang description ng imahe. For example, brown lighthouse over text na Lighthouse Coffee. Again, fill out ang disclaimer box kung may generic or descriptive sa mga salita na ginamit sa inyong mark at maglagay ng translation kung kinakailangan. Ang mga nilalagyan ng translation ay mga salita na hango sa ibang foreign characters, gaya ng Chinese, Japanese, or Korean characters, na kailangan talaga i-translate sa English para maintindihan ng examiner. At kung ang aplikante ay isang union o kooperatiba, i-click ang collective mark. Kung hindi, just skip this portion. At kung kayo ay gagamit ng isang set ng kulay, sa logo nyo, dapat ilagay ang generic color name sa color value para magkaroon kayo ng color claim. Then you may click on next to proceed. The next page ay kailangan nyo i-identify yung klase ng goods or services na covered ng application nyo. Pwedeng maglagay ng keywords na isa-search o mamili na lamang sa listahan. Kung keyword natin dito ay coffee at ito ay under ng class 30. You may also click on I want to provide my list. Basta siguraduhin nyo lang na tama ang classification na ilalagay nyo. Then click on next. Sa page 3, lalabas ang similarity report kung saan makita nyo ang mga trademarks na kahawig ng application nyo. Kaya importante talaga na mag-conduct ng trademark search bago mag-file para makasigurado. Step 4, kailangan ilagay ang detalye ng applicant. Siguraduhin na tama ang lahat para hindi magkaroon ng issue sa pagproseso. Dapat din ilagay kung merong representative ng aplikante at siya ang makaka-receive ng mga notices galing sa ITC. Then click on next. Confirmation page, pwedeng i-check lahat ng detalye bago pumunta sa last page. At huwag kalimutan na i-check ang declaration of small entity kung ang assets ng business mo or ng applicant ay less than 100 million pesos para maka-avail ka ng small entity fee. Maaari rin mag-submit ng Special Power of Attorney or SPA kung meron kang representative at ng Declaration of Actual Use kung ginagamit mo na ang marka. Sa huling portion, kailangan nyo lang ilagay ang payment details. Ito ang lalabas sa e-official receipt na ipapadala sa email nyo. Then, click on Submit once you're done. Didirekta kayo sa payment page kung saan kailangan nyo i-click ang Generate Statement of Account na nasa lower right ng page. Pwede kayong pumili ng payment channels nyo like DragonPay. Pwede rin gamitin ng inyong card through PayMaya. Sa DragonPay, napakaraming options. Merong online banking, over-the-counter, bayad center, 7-Eleven, and even GCash. Ang transaction details at payment instructions ay ilalabas sa new tab at ipapadala rin ito sa email nyo. Kung PayMaya naman, pwede nyong ilagay ang credit card details nyo at hindi nyo na kailangan gumawa ng PayMaya account. Pag successful ang pagbayad, papadalhan kayo ng official e-receipt through email. Dito rin nakalagay ang inyong application number na kinakailangan para sa pag-monitor ng inyong application sa aming public database.
Thank you very much, Ms. Danya, for walking us through the online filing of our trademark application. So here are the trademark-related fees. As mentioned to you, filing fees per class. You may also visit our website, ipofil.gov.ph, for this trademark-related fees. So what's next? After you have filed and paid your trademark application will go to the Bureau of Trademarks, and it will be assigned to a trademark examiner. So what will the examiner try to find out? First, he will try to find out the formalities. Has the applicant completely filled out the trademark application form? Then it will undergo a substantive examination. The examiner will find out whether it follows the registrability of a trademark. Is your trademark highly distinctive? Is it similar to a registered trademark? Okay. If the examiner will find something to question in your application, then he will prepare a registrability report wherein the applicant needs to respond within 2 months from the stamped mailing date of the registrability report. Okay. Once the applicant responds and the examiner gets satisfied with the applicant's responses, then the examiner no longer has questions in the application, then it will undergo first publication or the notice of allowance. In here, the office will try to find out whether someone or a third party will have to oppose your application. If after 30 days there will be no opposition, then your trademark application will be deemed registered, and it will undergo the second publication to notify the public that this trademark has been registered. But once somebody else opposed your trademark, then your trademark application will go to the Bureau of Legal Affairs for action. Okay. So, as mentioned, in the filling out of trademark application, the applicant should be able to supply complete details, especially email address, as everything, every communication will be through this e-correspondence or through e-doc file. Therefore, it is very necessary that you put correctly your email address. Okay? Everything will be done through the e-doc file, the correspondence and the communication from the examiner and the applicant. So now, how do you maintain your trademark? For example, your trademark has already been registered and you were given the certificate of registration. What are you going to do next? As I mentioned a while ago, in trademark, there is forever as long as you use your trademark and as long as you maintain your trademark. So how do you maintain your trademark? You have to file the declaration of actual use. The declaration of actual use is a requirement, is a maintenance requirement, and should be submitted on time. Non-compliance will result to the removal of your mark from the registry. Okay? So it is a maintenance requirement. So when do you file your declaration of actual use? A declaration of actual use is a proof that you're using your trademark. So it is filed within 3 years from the filing date of your application. Or, for example, you're already using your trademark now, and it's only now that you're going to file your trademark application. You can already submit this DAU, or declaration of actual use, within 3 years from the filing date, as long as you can attach actual labels of your mark. Because as mentioned, the declaration of actual use is a proof that you're already using your mark. So what can you attach in your application? Actual labels of your mark or pictures. If you use it as a signage, then you can attach photos of your trademark. Okay, next, the DAU is filed within 1 year from the 5th anniversary of the registration date and within 1 year from the renewal date. Okay, let's have an example. For example, your application has been filed on January 1, 2020 and has been registered on May 1, 2020. If we are to strictly follow this within 3 years from the filing date, the first DAU will have to be filed until January 1, 2023. Next, within 1 year from the 5th anniversary of the registration date, the registration date is May 1, 2020. Therefore, the 5th DAU will have to be filed until May 1, 2026. And the renewal DAU, it is 1 year from the 10th anniversary, from the 10th year or the anniversary. Then renewal date is, renewal DAU should have been filed until May 1, 2031. Okay, so non-compliance with the declaration of actual use will result to removal of your trademark in the registry, in the IPOFIL registry. So we're about to finish, but I'd like to give you some tips. You have to know your application number. The application number for trademark starts with 4, and we follow this format. IPOFIL has these codes for its applications. So 1 for patent, 2 for utility model, 3 for industrial design, and of course 4 for trademark. Next, you can use the Philippine Trademark Database. A while ago, I showed you how to conduct trademark search. It's the same database that you can use so that you can track the status of your application. Okay, so just key in this one and type in the trademark that you would want to look for or search for. Then from there, you will be able to track the status of your application. And when in doubt, don't forget to ask us. We have this following contact details. And lastly, I'd like to invite you to our iLeap IP sessions. It's actually a regular session that we conduct. It's open to the public and it's for free. It's every Tuesday. It's a regular IP learning session. It will run until this November, and this is every Tuesday, every afternoon of Tuesday. Okay. So on September 21, we will have the introduction to patent, utility model, and industrial design. Okay. So just visit our website so you can register if you want to join our iLeap IP sessions. Also, we have the program. I'm sure most of you already know about this, the Wanna Make a Mark. It's a trademark registration incentive program that allows the eligible MSMEs to have their trademarks registered at a reduced cost. Okay, you may coordinate with the nearest DTI office for the Wanna Make a Mark. And just recently, this was This initiative has been firmed up. It's IPOFIL Memorandum Circular 2021-021. It's establishing the Trademark International Registration Incentive Package, also known as WANA for the World. In the previous slide, we had WANA Make a Mark, that is local filing of trademark. But this one, it's for the International Trademark Registration Incentive Package, or the One for the World, which is also in partnership with the Department of Trade and Industry. So you may ask for more information with our DTI offices. Okay, this one, you will be able to waive the handling cost of the Madrid Protocol application, which is about 2,600 pesos. Okay, so this is a very new initiative. So you can check this out in our website later on. So always remember that intellectual property protection is a race. Be the first. We follow the first to file rule. Therefore, once you have your you have conceptualized your trademark, then file it right away so that you get to file first and get protected first. Lastly, I'd like to leave you with this hugot, trademark ka ba? Bakit? Kasi you give a brand new meaning to my life. So, protect your brand and register your trademark. Thank you very much.